Hello, it's Kuldeep Clair, consultant solicitor with Sterling Law, specialising in employment. I'm going to be speaking about the hot topic which has taken over the world in the last couple of weeks at the moment, which is the coronavirus pandemic and how it's affected the world of employment, and particularly from the point of view of employers at the moment. If you're an employer, this is going to be of absolute vital importance to you if you're not sure of what you can and cannot do in terms of meeting your business needs, dealing with the requirements of your business in terms of what you can do with your employees, what you can't do, how to deal with the effect of the virus, the effect upon your business, and the risks that it poses to your business, and generally in terms of cash flow issues, economic issues posed to your business, and the biggest way in which it affects your business is the effect upon your employees. So the way in which it affects employment law and what you can and can't do is of absolute vital importance at the moment, given that people are just talking non-stop about the coronavirus pandemic. So here we go. Now, the vast majority of companies affected are good, solid businesses, but because of Covid-19, they're facing supply chain challenges and a reduction in demand. In order to meet their cash flow, businesses need to consider every way in which they can manage their costs in the short or medium term. And one of the major costs, if not the major costs in many businesses, is the cost of their employees. Reducing employee cost is not easy at all. Companies would be unwise to wait until they're in financial difficulties before addressing that issue. So how can companies deal with that problem? It seems to me that there are three main options, and when I say there are three main options, it doesn't mean to say that those options are very easy. The options are very difficult, and you must take professional advice before opting for any of those options in your particular circumstances. That's the crucial issue. You need to take professional advice depending upon your particular circumstances. So it's all very well listening to this podcast and receiving the essential basic guidance, which is all very important, of course, to give you some guidance as to how to proceed, but you must take professional advice according to your particular circumstances as well. So, what are the options? Firstly, you can reduce employees' pay. Secondly, you can lay off employees temporarily or move to short-time working. Thirdly, you can have large-scale dismissals on the grounds of redundancy, reductions in pay. In the majority of cases, employers are contractually obliged to make payments to employees on terms that have been agreed and often in place for a number of years. Reductions in pay can only be made in line with agreements with the employee. For employees that have been employed for less than 2 years, you can obviously, once you give them notice, you can obviously re-employ them on different terms, different conditions. This really overlaps with the same issue of laying them off or making them redundant, because what this really amounts to is the question of whether you can alter their terms, whether you can terminate their contracts, re-employ them. For employees that are employed for less than 2 years, it's a little bit easier. The problem really arises for employees who are engaged for longer than that period. Employees that are dismissed in this way will be entitled to their contractual or statutory notice, whichever is longer, and they'll be entitled to be paid their contractual rate of pay throughout that notice. Many employees will agree to a reduction in pay voluntarily if it means that their employment can be continued, and employers should talk to their staff as soon as possible. You should always, try and agree things if you possibly can. Agreeing things is always better than imposing things. An agreement should be recorded in writing for the sake of good order, and you can speak to a lawyer such as me to draft an agreement, have an agreement drafted to protect your position in the future if any agreement is challenged. If an employer imposes a unilateral pay reduction, there is a risk of employees resigning and claiming constructive unfair dismissal, or bringing claims for breach of contract or unlawful deduction from wages. That is quite conceivable. You need to be very careful to avoid that, and this is where you need professional advice depending upon your personal circumstances. In extreme circumstances, if you're an employer, you might want to take a risk of facing such claims rather than going out of business. That might be a last resort. It's not an ideal choice, though. So an alternative possibility is laying off workers on a short-term basis or imposing short-term working. Laying off, of course, is not the same as redundancy because laying off is basically intended to be short-term. Short-term working involves providing employees with less work and therefore lower pay for a period of time, while still retaining them as employees. Like a layoff, it's a short-term measure, often designed to deal with a short-term shortfall of work. Whilst this route is attractive can be attractive to employees, it can be fraught with a number of difficulties. Unless there is an express contractual right to a layoff, imposing short-term working can mean that you are in breach of contract with your employee if you don't provide work and obviously pay to your employee. So it could lead to a claim for constructive unfair dismissal. That could be a big problem. Well, it definitely will be a big problem. It's possible for an employer to argue that there's an implied contractual right to a layoff or to introduce short-term working. And I often get employers that want to introduce such an express term in their contracts. But it's not really quite as easy as that. I often get employers, that want me to draft employment contracts, and introduce all kinds of terms, and they often, with all due respect to them, seem to think they know how to draft a contract better than I do. I sometimes wonder why they ask me to draft a contract when, if they're telling me exactly what to put in the contract. But it's not really quite as simple as that, because these sort of terms can sometimes badly backfire because they're not effective, and they can look very dubious if the employee then brings a claim before the tribunal. They can make an employer look very bad, and it gives a wrong impression to a tribunal about how scrupulous an employer is. Even if you have an express contractual right to lay off an employee or introduce short-term working, where the employee has more than 2 years' service and you've laid off an employee for a lengthy period of time of, say, more than 4 weeks, then the employee can claim statutory redundancy pay because the employee is allowed to treat it like a redundancy. So let's look at the third option that you may have when you're dealing with a difficulty caused by a lack of work, or a difficulty caused by the shortage of work or economic circumstances caused by Covid-19. That option is straightforward redundancy. Now, redundancy is available as an option in this sort of circumstance, but of course we should all be aware, and you should be aware of the difficulties in imposing a redundancy. The difficulties in using a redundancy in the COVID-19 situation is the same as any difficulty in a redundancy situation. It's got to be a proper redundancy situation. It's got to be what is defined as a redundancy in law. In other words, it's got to be a reduction in business. It's got to be caused by a difficulty in the business, reduction in business need, etc., as defined under the Employment Rights Act. You've got to select who you make redundant very fairly using the criteria in the Employment Rights Act. You've got to be very fair in your selection procedure, and you've got to be very objective in who you select when you have the option of selecting certain employees. Obviously, for employees who have not been working for 2 years, you don't really need to be too concerned, as long as you're not using criteria which are discriminatory on grounds of race, sex, disability, orientation, or age, or something like that. But for employees that have been employed for more than 2 years, you need to use objective redundancy criteria, and this is where you would be well advised to get professional advice from someone like me. Trying to deal with a redundancy without proper professional advice is very risky indeed. So those are the three main issues, the three main ways in which you could deal with staffing issues caused by the COVID problem at the moment. As I said, it's well worth getting professional advice at every stage which apply to your personal circumstances, and get tailored advice in your own personal circumstances. Best of luck. Do get in touch, and I'll always be available. The last thing we want to do as lawyers is be seen to be taking undue advantage of the present very desperate circumstances that businesses are facing. So we're offering our advice at discount from the usual rates. We're always happy to help out businesses deal with this very serious problem, which is a very desperate issue for businesses, which is causing suicidal thoughts amongst lots of people, both employees, employers, and other people that are not working around the world. Give us a call. I'm available on 074 84 614 090, and we're available at Sterling Law, and you can contact me on my email address, which is Kuldeep, that's KULDEEP, at sterlinglawyers.co.uk. Thank you.